recognise that effectiveness has largely dwindled into nothing when it comes to a legitimate basis for personal jurisdiction. Because apart from anything else, there are now procedures for recognising judgments abroad and executing them abroad, potentially. I take your point about comity. Have you, or are you aware, has it ever been debated in the context of this case, are there any relevant principles under the rules of private international law, conflict of laws, concerning the recognition of a competition judgment in one country to be recognized in another? Because as you know, generally in private international law, judgments in one country will be recognized in another if what they call an internationally recognized basis of jurisdiction exists. And I think that would effectively be a form of, it would be what we would call personal jurisdiction. And it seems to me that the adequate connecting factors test, having regard to the EU and American authorities to which the Competition Appeal Court had regard, was effectively having regard to the sorts of factors which internationally are regarded as acceptable for a competition authority in a country to exercise jurisdiction over a foreign actor. So, but on the question of recognition of foreign judgments in the field of competition law, is it something that you're aware has been investigated?
No, I'm not aware of that, and this has never been debated. I mean, the debate in this court has now taken a different and probably more sophisticated turn in respect of that, but no, it wasn't before. But in terms of, just coming back to the point about the adequate connecting factors, we submit that would be an important consideration as to whether or not this is an appropriate judgment which could be recognized overseas. But can I just go back to the premise on which this question is based? And, you know, yes, we reiterate, we don't say that personal jurisdiction subject matter can be revisited in this case. I mean, just to clarify that. But if the court were to do that or express comments on it, we do submit that adequate connecting factors is the appropriate development of the personal jurisdiction, and it would be in line with international principles.
And insofar as adequate connecting factors is concerned, if the argument is, well, a conspiracy relating to the RAND is a sufficient adequate connecting factor, would that be caught up in the raised judicata point? Because it seems to me that if that was an adequate connecting factor, the pleaded case against the foreign banks was already sufficient for personal jurisdiction, because all of them were alleged to have conspired in respect of the RAND.
Yes.
So
I think
it seems to me that insofar as this case, I'm not saying any other case, but as between these parties who didn't appeal on either side in respect of the first appeal court judgment, we appear to have a finding that mere conspiracy in respect of the RAND by foreign actors is not enough.
Yes.
And am I right? Did the appeal court say what would be enough? Would be if it could be shown that in so conspiring, they were conspiring together in the same conspiracy with South African banks?
That's my recollection, yes. So we submitted, yes, it would be hit by it. 3.3.1 is you had to, in the case of all the named respondents, set out the facts which are sufficient to allege that there are adequate connecting factors between the parties and the jurisdiction sufficient to establish personal jurisdiction. They wouldn't be necessary if it was simply in respect of the subject matter. If it was simply in respect of the RAND, it wouldn't then be necessary to show that there was an adequate connecting factor with each of the named respondents in terms of 3.3.1. So our submission is that is hit by that point.
Then just one other question. I don't know whether this is in the record, so I don't want you to tell me if it requires on drawing on knowledge that isn't properly before us. But do we know whether all the details that are given of specific interactions in the old GITS chat room and the ZA chat room, do they represent the entirety of the interactions? In other words, do we know that the Commission had access to the entirety of the chats that took place over the full period, or is it plausible that perhaps they only had access to some through a leniency applicant? Or we don't know?
I don't know, and perhaps the other party, I know Standard Bank was trying to get the record, and perhaps they might be able to speak to it, but I don't know. But what I do, you know, for Shepherd, we asked them for information, and they just shut us down. So we don't know what they had. We know they had access to the leniency applicants, but they also had some access before because they pleaded it. I don't want to, like the Commission can give evidence that's not here, so I can't say.
Because I must say, I would be personally staggered if parties in the old GATS chat room who saw some advantages to themselves in manipulating the US dollar and the rand didn't also see the advantages of manipulating the US dollars with a host of other currencies.
Oh, yes. Yeah.
So on the face of it, it strikes me implausible that the old GITS chat room was confined to discussions about manipulating the dollar with the rand.
Indeed. And in fact,
it would have been fairly small beer, I should have thought.
Yes, yeah. And in fact, that's why the initiation, it struck me when reading the initiation, which is attached to the referral, that there are these four currencies and the rand just happens to be one. And yes, so Mr. Cook is interested in the rand. Yes, I suspect was very small.
You say the initiation statement says that old GITS...
No, it doesn't say old GITS, but it says, it refers to the, I'm just trying to find it while on my feet here. But it refers to four different currency pairs in respect of which the parties were alleged to have colluded. It says, the above-mentioned conduct includes, but not limited to the following currency pairs: USD rand, Euro rand, Turkish lira rand, Mexican peso rand.
But that's all with the rand on the other side.
Yes,
I'm thinking of the dollar.
The dollar in the southeast. Yeah, no, indeed, yes. No, I think it's almost
we don't know.
We don't know, but it's almost certainly the case.
Thank you.
I just wanted to, my learned friend for the Commission mentioned the Metsila case, and it relies on the raised judicata. Would you give me 1 minute just to address that case, or are you happy that that's not a relevant issue?
1 minute.
Yes. We don't see the relevance. It was raised in the context of raised judicata in overturning orders not before the court. We read the judgment. It's an application against a...
I'll give you 2 minutes.
Okay, it's an application against a pension funds adjudicate awards in 30p of the Act. That went to the High Court, to the full bench, to the SCA, and then to this court. This court overturned a decision of the SCA, which in turn overturned the full bench and the single judge of the High Court. But this court disagreed with each of those judgments. So it overturned the SCA order, which necessarily would have meant that the full bench and High Court judgments survived, full bench having dismissed the High Court one. And because it disagreed with those, it had to overturn those as well. But we submit that's the normal course. That is nothing like the present case and nothing like the raised judicata problems that raised in this case. It's completely not on point with respect. Thank you. I think that might have been a minute.
You want to do? Not on this one. Okay.
Mr. Follum, I think, Mutsila, the point that the applicants were making, there was a judgment, Guarneri,
Yes.
SCA judgment,
Yes.
and that question was not squarely before this court. And this court in Mutsila said that that judgment was wrong. A part of the judgment had been wrongly decided by the SCA. And I think the point that the applicant is making is that where there's a point of law that appears to have been incorrectly decided, it is open for this court to deal with it.
Yes, no, thank you, Justice Schwan, but I acknowledge that. I'm sorry, but that doesn't mean that the parties in that Guarneri case were now allowed to get the benefit of this court finding it was wrong. Of course, this court can say another judgment is wrong, but it doesn't mean that they've opened the fight between Guarneri, in that Guarneri case. And that's the difference here. They want to overturn it and open the fight between us.
So if I understand your submission, you're saying that this court could, if it was of the opinion that that point was wrongly decided, but it might not benefit
Indeed.
the applicants.
Indeed.
Because of the question of res judicata.
Issue stop. Indeed. Thank you, Justice.
And if I may, thank you, Deputy Chief Justice. Is it the submission on behalf of the respondents that you represent that and this is linked somewhat to Justice Rogers' question as well, that the Competition Act has no extraterritorial reach at all when it comes to personal jurisdiction?
No. And in fact, as I think the Commission pointed out, because in light of Section 3.1, we couldn't argue that, because that says it affects conduct within or having an effect within South Africa. So if you're a foreigner and you're acting overseas, but your effect has its direct and substantial foreseeable effect in South Africa, you could be caught, but then there's the personal jurisdiction hurdle as well. So it's certainly not confined just to within the country.
But if that's a proper interpretation of the Act, can that be so, given that the purpose of the Act is, and I quote, to restrain particular trade practices which undermine a competitive economy?
Yes. Well, so, going back to the debate, so it applies extraterritorially, but then one's got to read it against the overlay of the common law, and unless the common law is now regarded as impliedly repealed, which for reasons we submitted, it wouldn't be consistent with the Act to read it, and you've got that further one. We submit it wouldn't fundamentally undermine the purpose of the Act to do that. And in fact, the Act itself contemplates, as I will debate with Justice Majid, that you can't get a penalty against them, you can't subpoena them. So in effect, there's always going to there is a limitation in any event. So the irony of this case, the end of it, they couldn't impose a penalty against my client. And so there are the indications in the Act that, in fact, it's while it's extraterritorial, it's not completely wide against the foreign.
Yes. Thank you. Thank you, Mr. Farlow. Thank you, Deputy Chief Justice.
Thank you. Sorry, Mr. Farlow. I'm just trying to get my head around the correct approach to exceptions. And in a sense, what emerges from this case. As I understand it, Rule 15.2 of the Tribunal's rules set a standard for pleading, if I could call it that. It would have to be material facts or points of law relevant to the complaint. In the Tribunal judgment in dealing with exceptions, the Tribunal sets out its approach to dealing with exceptions. And its approach is recognizing that it's a body that's sui generis, that it has got inquisitorial powers, but that ultimately the overriding consideration must be fairness. It also repeats the tried principles in our law that the exceptions must be decided on a interpretation of every reasonable possibility, and that the allegations must be taken as correct. So it doesn't contemplate that the Tribunal, considering the exception, would, as it were, test the veracity of the allegations, but would accept the correctness of those allegations. Now, that being said, when I look at the CAC judgment, the connecting factors test, and that's set out in paragraph 85, I think, of that judgment, says on the one hand that there has to be a sufficiency, a sufficient connection between, it should be sufficiently connected to South Africa. But then in the last paragraph of that, the last sentence of that paragraph, it says it follows that to sustain an argument that there was sufficient connecting factors, the need is to provide clear evidence of linkages. So the CAC speaks of clear evidence, and then in the following page at paragraph 88, it then, in dealing with the position of Cook, as regard to the exception affidavit filed by your client, in, as it were, controverting the allegation made with regard to Cook. So what CAC is doing is it's subjecting, as it were, an allegation of a material fact that our law says you must take as correct. It's testing that, and it's then proceeding to dismiss the exception on the basis that it doesn't meet the test. And I suppose that the same would apply to inferential reasoning. One could apply the Blom test ultimately to whether you accept that reasoning. But is it so that at exception stage it's permissible? Because the danger here, Mr. Farlow, is that one, in doing so, you lose sight of the sui generis nature of the tribunal. And secondly, you actually sort of skirting into the merits of the case. in determining an exception. And so I have some sort of conceptual difficulty with that approach and its consistency, as it were, with generally the law on exceptions, but in particular with regard to how the tribunal is meant to function. So, yeah.
Yes. Thank you, Justice Collipin. Yes, we noted the comment in it's paragraph 88 about the exception affidavit. And before I get there, though, as I've said, the parties for pure excipients might have a different view, but our position is, well, we've got an exception against one, and then we've got a joinder against the other two. And so the test is different in respect to the joinder. You can then, we say you must at least make out a prima facie case on the joinder, and then for looking at that, you look at the facts that are made, that are pointed out. So, for example, the general test for prima facie is, if the respondent raises a thing that you can't answer, well, then you must accept that to be right. And so we say that applies in that context. So we're in a slightly different position to the pure excipients. And that then leads on to the observations that the court made about the CAC referring to our exception affidavit. As in this court, what I argued in the CAC 2, was reference to the joinder affidavits. So I made the same argument, and I don't know if it was an error in there or whether they looked at the one, but I made the same argument with reference to the joinder affidavit, and I said it's common cause effectively in the joinder that a MLPFS is the party. So then the argument is the one that I had with Justice Majid. Well, in those circumstances, is it sensible in the interest of justice or appropriate to then close your eyes in the exception, or can that then also influence, and usually perhaps in this context. So it's not a pure, I wouldn't, from my side, and it may be that others were different from you, I don't have to defend an argument that on exception you can take into account facts given by the party in respondent. The fact that the tribunal allowed an exception affidavit in itself might have been a call that they shouldn't have made, but they did do it, and perhaps they did it with reference to the other provisions, because invariably then facts come in. But from our side, we don't have to defend that, and I didn't try before the CAC, and I'm not now before this court.
Okay, I just raise it because I'm just concerned whether that's reflective of an attitude on the part of the tribunal, of the CAC, as to its approach to how it sort of links its conception of the connecting facts test to the standard of pleading, and to how it will deal with exceptions. And other parties may deal with it, but that's a concern I have.
I fully appreciate that concern, Justice Collipin, but as I say, we don't have to get there. And in terms of an inference, we would simply say the question is, well, yes, you take the facts as correct, you say I was a member of the Olgit's chat room, and then is it a plausible inference that we then knew about the SOC worldwide? And that's our response. Please.
Sorry, Mr. Farnham, I didn't read my notes properly. There's one more. Now, this concerns a bank's participation in the overall conspiracy. If my note is correct, yesterday you submitted that a bank's involvement in an SOC can only be measured through a trader or traders' activity or participation in the chat room. And a lot of the submissions this morning concerned that aspect with regard to jurisdiction. Did I make that note correctly? You say it's only through that the participation can be gauged.
Yes, so we said that you've got to look at the trader and see what the trader did, because that's obviously the link. And so if the trader's not part of the, well, say in the first instance, the trader's not connected to the company, then you're out. But if the trader is connected to the company, you look and you say, well, what did the trader do? In this case, it's that their pleaded case is because you were in the chat room, therefore you knew about it. And in our case, therefore, it's because you were in the Olgit's chat room, you knew about it. So that's the link.
You would have heard yesterday the submission by Mr. Nkatobi that's the first part. But there's a second part, that if the allegations are that the trading pattern matches the overall strategy and discussions in the chat room, that would implicate a trader as well, even if you don't satisfy the first part. In other words, let's say Mr. Cook is alleged to have discussed with other traders that he will pull or hold his trade for a certain time, so as it was put, to reserve liquidity for each other, which is a serious allegation, if proved at trial, but something along those lines. And it turns out, ex post facto, that that's in fact what happened, that liquidity was reserved, or in another instance, they agree on the pips for that period. And it turns out that actually that is what happened. Is that just sheer coincidence? Is that something that that can be summarily dismissed? Because here we're just dealing with allegations at exception stage.
No, I would agree with respect that if you're looking to say, well, was there an SOC? And this is one of the factors that they allege for saying why they think there's an SOC. You look at the trading patterns. So that's correct. But then the next question is, were you part of the SOC? And we know that the Commission acknowledges the test is you must know or reasonably know about the other party's conduct and what they're doing. So we must reasonably know that in South Africa on a Reuters trading platform something's happening, or Investec is talking to someone allegedly, or Macquarie is talking to someone. And so that's why we say that's another thing. So it's not, is it enough that you can infer there's an SOC? Yes. But is it enough to show that we are part of the SOC? No, and it could be, as I say, that we were just party to a bilateral exchange or something else. And that's why that I did emphasize that third requirement for the SOC is the key one for guiding us. And they have to show that. And it can't show there was an SOC because, yes, there is an SOC maybe, but they've got to show we were part of the SOC. And we can be, because it's guilt by association. Well, effectively, you don't want to make it just guilt by association. It's sort of, you're going to be responsible for the conduct of others, so you must at least know about that. And that's why that's a key factor, which is different to the point that your court made.
Of course, you can do a common purpose in criminal law, but in your submissions, you kept mentioning yesterday and again this morning that the old GITS chat room may have been set up for benign purposes. A, what was benign in the chat room? What was discussed that was benign in the chat room? And B, what does it matter? As long as it's turned bad, or there's mixed the good with the bad, surely if there's enough allegations regarding the bad at exception stage, that should be adequate. But what was benign in the chat room? Could you maybe point me to some?
No, well, we don't. I mean, the pleaded evidence, what they've just taken out are some instances of bad things. So if the chat room lasted for 6 years or more, and they've taken out certain examples. But what we've said with reference to, for example, foreign cases, that some information exchange is necessarily needed. And if I want to trade with you, I need some information. I need to be able to talk to you, and I need to get some information about certain things. So the fact that there's a forum in which people can communicate and exchange information is not in and of itself a bad idea.
Of course, it must be so. I mean, nobody can argue against it. But once you exchange commercially sensitive information, this is what my client is going to do, and this is what he's not going to do, and so on. Surely then it's no longer benign, and then the whole chat room gets abused, and this is where the allegations are now.
Yes, well, what we don't know, I mean, we've got various instances which, say, well, this happened. Of course, it's over a period of 6 years that Mr. Cook was 40 instances. We don't know if there were, they don't say that it was, and this is the point that the tribunal made the first time around. They don't say it was originally fine, but has now become an overwhelmingly bad, malign place where people collude, and therefore simply by joining it is bad. They don't say anything about that. They just give examples of bad instances, and then that's why we then say, well, in those instances, going back to what the tribunal said initially in CT1, well, you can't say necessarily just joining it. And that's the point, for example, they say Shepard just joined the chat room. Now you can join a chat room in 2007. I think it was that he joined it. Well, was it a badge? Did it serve good purposes? Could you have joined it because that's the way you trade? But they don't say it's an overwhelmingly bad chat room. They don't say it was only bad. And as I said,
looking at all these instances and what Katz and others were up to me it looks bad enough. But let's leave it there. Thank you, DCJ.
Thank you, Mr. Fallam. Oh, looks like another question for you. Thank you.
Mr. Farland, I've heard you on joinder and exceptions and so on, but are you not setting the evidentiary bar too high in this matter? You've got evidence on pleaded of an SOC, you've got evidence pleaded of traders of particular conduct. of chat rooms, of the consequences of the trade. Is that not enough to reach the threshold required by the Commission?
Justice, just going back, I mean, our point is yes, that there's evidence of collusion, of trading, and there's maybe evidence that there's even maybe evidence of an SOC. But is there an evidence of an SOC involving us? And that goes back to the question of what are the requirements for an SOC. So we would respectfully submit that it's not enough that certain actions of Mr. Cook might be regarded as collusive. You've got to show that he was part of the overall plan and that he knew of the overall plan, and therefore it's not enough to say, well, perhaps you could find him guilty on certain things. You've got to show that he was part of the SOC, and that goes to the requirement of the SOC that I've dealt with, and that's ultimately turns on the question: can you infer from his membership of the Olgit's chat room that he was part of an SOC with SA Banks?
What is pleaded not sufficient? Because of course, at a later stage there'll be more detailed evidence. But really what you're saying at this stage is that there must be more detailed evidence pleaded in order to meet the threshold required. But is that not too high?
Well, what the CSC said in CSC 1 is that if you're relying on inferences, you must plead the material facts on which the inferences are based. And they tried to do that, but the material fact on which the inference is drawn that we are part of an SOC with South African banks is purely that we were part of a chat room. So that's the material fact. And they draw an inference, and we say that's not an implausible inference. And in terms of the test, we say it's not simply an exception, it's also the question. You had a chance to flesh it out in the joinder. When you were dealing with MLPFS and Banner, you could have given us a little bit more. In fact, in that context, we also said, well, tell us a bit more about Shepherd, please, so that we can respond, and they didn't do it. So then some of the authors, their own misfortune, we would submit.
Thanks, Mr. Fowler.
Thank you, Chief Justices.
Mr. Loxton, it's your turn. We will allow you your 30-minute uninterrupted time, meaning we won't adjourn at 11:15. We'll adjourn when 30 minutes is up.
He says it's 15. Let's just check.
Sorry, Mr. Fowler, I'm just doing this. You have 30 minutes uninterrupted time. Is that correct?
30, yes.
Yes.
So I'm going to take 15 before tea and 15 after tea.
No.
Oh,
We want you to argue the whole time.
the whole thing. So
Yeah. Then we'll take our adjournment when we finish.
that
Yes.
is perfect.
Oh, my colleagues doesn't wanted to know you're for which party. You for the,
ANZ,
yeah, you for the ANZ group, isn't it?
first responder,
Yeah.
the merest of minnows, the
Yeah.
smallest respondent that's there.
Thanks.
Deputy Chief Justice, what I intend to do is to first make a few observations about res judicata, and then its consequence for what may be advanced as errors of law, and then to examine what may not be advanced before this court, namely errors of fact, and then to establish whether there are any errors of law which affect the decision of the CAC in its second decision in relation to ANZ. So I see that that there are two other respondents that have already had something to say about res judicata, and I might say right at the beginning that I fully take what Justice Rogers said about preemptions, and with respect, I think that he is correct and that this is a question of res judicata and not preemption. So the starting point then would be, well, what have we got here? And there is a case not yet, as I understand, cited by the parties in relation to res judicata, and it's TWK Agriculture Holdings versus Hoogveld Boerdery Beleggings, and it's 2023 5 SA 163 SCA. Now, that case dealt with the question of the circumstances under which a refusal of an exception would be final and definitive in effect, and then give rise to an appeal. So, of course, it's right that the granting of an exception would be final in effect and would give rise to an appeal, but the reverse is not necessarily correct. And the remarks of His Lordship, Mr. Justice Unterhalter, in that regard at paragraph 43, are insightful, are helpful because of the guidance they give on why it is that when exceptions are brought in relation to jurisdiction, they are necessarily final in effect and necessarily give rise to a right of appeal. And His Lordship there said the following at 43, May's Board does recognise a carve-out to the rule that the dismissal of an exception is not appealable. An order dismissing an exception will be appealable where the exception challenges the jurisdiction of the court. That is so for the reasons that were explained in Moch. Where the challenge concerns the jurisdiction of a court, and hence the competence of a court to hear the matter, the decision of the court is considered definitive and appealable. This is consistent with the principle enunciated in Zweni, because the decision as to jurisdiction is considered final. This position is entirely justified because an error as to jurisdiction, if not subject to appellate correction, would permit the court below to proceed with the matter when it had no competence to do so, rendering what it did a nullity. That is plainly an undesirable outcome. Furthermore, a challenge to jurisdiction is taken at the commencement of proceedings until this challenge is finally resolved by a court, should not exercise coercive powers that compel compliance. So in what followed in CAC 1, there was then a decision as to jurisdiction. And effectively what was said there is that Section 3.1 of the Act did not imply the repeal of the common law in relation to personal jurisdiction. And that is said at page 87 of the record in CAC 1. It's paragraph 22 of the judgment. And the court said, the tribunal also found that 3.1 of the Act could not be read to imply a repeal of the common law requirement for personal jurisdiction. I stop there to simply remark that the tribunal and the CAC were ad idem on that question. The question which was then where the CAC departed was what to do about that and how to deal with it. For this reason, it accepted the argument that a traditional declaratory order, one that has civil but penalty consequences, is not an order we can competently give without personal jurisdiction over the peregrinous respondent. Then at page 100 of the judgment of the papers, it's paragraph 51 of the judgment. The court then develops the common law in relation to personal jurisdiction at paragraph 51. And I note in the Commission's heads of argument that they said that that was the right thing to do, although they may disagree in other respects. And then, as we know, at page 116, the court ordered, consequent upon a finding that personal jurisdiction was required in the particular form which the court adopted, and that consequence was that the new referral affidavit must be in addition in the case of all the named respondents set out on the facts on which the Commission relies to allege that there are adequate connecting factors between the parties and the jurisdiction of the Competition Tribunal sufficient to establish personal jurisdiction against all the named respondents. So that much then is clear. That's the order. And we know that there was no appeal against that order. In fact, quite the reverse, because when one goes to the referral at page 374 of the papers, paragraph 9, the Commission says the following: in accordance with the order of the Competition Appeal Court on 28 February 2020, the referral affidavit replaces all previous referral affidavits filed by the Commission in relation to this matter. And in that referral affidavit, the Commission attempted, we would say unsuccessfully, to comply with the order and to establish personal jurisdiction. So it is clear that the Commission itself accepted that there had been a final and definitive finding by the CAC in its first decision to the effect that the 3.1 of the Act did not dispense with the common law requirements of personal jurisdiction, and that personal jurisdiction in a developed form had to be proved. It was really in this court for the very first time that circumscription of their right to raise 3.1 as a sole form of jurisdiction arose. Until then, they were happy and content to run the second hearing in front of the tribunal and the second hearing in front of the CAC on the basis that the CAC had definitively decided the question of jurisdiction. And you can also see that from the second CAC decision, which is at the particular paragraph is at 262, it's paragraph 83, and there the CAC says, so much for subject jurisdiction in respect of personal jurisdiction as it pertains to the Peregrini banks. The court in its 2020 decision said the following, as it was applicable to Peregrini banks, given the very objective of the cartelists was to manipulate the USD-ZAR exchange rate so that they could make higher profit, common sense and logic tells us that it would be foreseeable that customers would suffer as a result, either directly as investors in a given transaction or in the price of goods and services for export or import. And then it says, ultimately the tribunal came to the conclusion that for the establishment of personal jurisdiction had been established, for at this stage the inquiry into jurisdiction requires the tribunal to decide whether its forum is appropriate and convenient to adjudicate on the alleged conduct of the foreign respondents. Now, what that then means is that everybody concerned, the respondents, the tribunal, the commission, the CAC in CAC 2, accepted that the question of personal jurisdiction as a requirement had been finally determined in CAC 1. Now, that would mean that it is no longer open to the Commission to advance an argument on the basis that 3.1 is the exclusive test for jurisdiction, and that as long as there are effects in South Africa, the tribunal has jurisdiction. But it then goes further, because when one's looking at what this court would be inclined to hear, we know that this court is disinclined to hear disputes relating to facts. That's not its function. And so the court is concerned with disputes relating to errors of law. Where there is an error of law which is identified, the next step would be to say, well, you erred, for example, taking the Commission's case, you erred in CAC in finding that there had to be a conspiracy between foreign banks and local banks. Then it would be possible to say, well, because in this particular case, that was the test you adopted, you're finding that there was no jurisdiction established because there was no contact between foreign banks and local banks, that finding may be upset. But where there are findings which are unconnected to any error of law, those findings may not be upset in this court. And that is where I would then get to the case of ANZ. Because what I would wish to demonstrate to the court is that when the CAC deals with ANZ, it deals with it at a fundamental level of causation. It's not even dealing with it at the level of personal jurisdiction or subject jurisdiction. It's dealing with it at the level of, was there an infringement of Section 4? Is ANZ guilty of an infringement of Section 4 because one of its traders performed an act or was guilty of an omission which demonstrated collusion of the kind contemplated by Section 4? And so it's important then to see how this was dealt with by the CAC. And I'd ask you then to turn to 266, which is where the court deals with it. And in paragraph 95, the court says, there is no doubt that Katz is a central player in this case brought by the Commission. I'll stop there for a moment. What you'll see from both this judgment and from the reference is that Katz is said to be employed from 2013 onwards. Tezel until 2012. Now, the problem that they have with Katz is that the last identified chat in which Katz is involved is October 2012, before he gets employed by ANZ. And in fact what happens is Katz goes off the air from being prolific to complete silence. Now one may speculate why that is so. It may be that the investigations have begun by the SEC, but the fact is that there is not one peep from him. And to go back then to the CAC's decision, he says, the difficulty, however, the CAC says, the difficulty, however, is that in every instance of participation in the impugn conduct alleged to have been carried out on by Mr. Katz predates 2013, the year in which he joined the fifth respondent from another bank. So I'll stop there for the moment, because what the Commission has attempted to do is to say, well, who knows but that Katz continued. But you can't base your case on ignorance. You can't say, I don't know this, therefore you must make an assumption that he continued, when everything you have demonstrates that he hasn't continued. So where the facts which you do have demonstrate an absence of continuation by Katz, the inference that is sought to be drawn that Katz continued is simply wrong. But there's a further difficulty with that, and it's a difficulty which permeates the submissions made by my learned friends in respect of Katz and Tezel. And that relates to the nature of their involvement and the inferences they wish you to draw and the assumptions they wish you to make. Those are matters of pure fact. If the CAC got it wrong if the CAC should have said, actually, you, Katz and Tezel, are implicated in this overarching conspiracy, and should have said, I'm going to assume that Katz continued, and maybe something will turn up in the wash. That's not a legitimate complaint, because that's not a complaint which involves an error of law. It's a pure factual inquiry. Then he goes on to Tezel, and I'll demonstrate to you in a moment that what the Commission does is it misrepresents its own referral. At paragraph 96, the court says the only reference to Tezel in the referral affidavit is the following. On 18 October 2012, Katz, Ayer, Williams and Cummins were participants in an implicated chat room in which the following communication took place. Katz and Ayer matched each other's opposite fixed positions in order to offsell their respective exposures at the upcoming fix. Ayer copied and pasted a portion of the communication between Madras and Tezel from another chat room. And the court goes on to say, what precisely is meant by copied and pasted is not clear, not made clear, nor is there any suggestion that Mr. Tezel participated in a chat room or any similar discussion with other traders. But the Commission's case relating to Katz concerns the period 2 October 2007 to 18 October 2012. That is before he joined the fifth respondent, and no participation on the part of Tezel, whether active or passive, is shown in respect of any of the chat rooms. This justifies the conclusion that no case was made out sufficient to find the fifth respondent was a participant in the overall SOC as pleaded by the Commission. Now, none of that flows from an error of law. All of that is a question of factual conclusions which the CAC drew from the pleadings which the Commission had put up. Now, you will have heard from learned friends for the Commission, they'll say, well, you know, these are exceptions and it's difficult to know exactly what happens, and maybe in the fullness of time, something will come out of the wash. But that is a profoundly unfair approach to pleadings. It's fundamental to pleadings that you alert the other side to the case to which they have to meet. And that's why they were required to plead the material facts, not only because of CAC 1, but also because of the rules of the tribunal itself. So that they were obliged to say, the case against you is that Mr. X, employed by you at this time, performed that act in furtherance of this conspiracy in breach of Section 4. That they had to say. They can't say there was a conspiracy. You all participated in the conspiracy. The conspiracy was frequent. There were many chat rooms. Because that's unhelpful. How are we supposed to deal with that? So now we have a look at the case they made out, because we're only here to deal with the case that is made out. And as I said, in the case of ANZ, the interesting thing is that it can be decided at the most fundamental level. It can be decided without interrogating the subject matter test, without interrogating the personal jurisdiction test. It can be investigated at the level simply of, were you involved in the conspiracy or not? The CAC said, you haven't pleaded sufficient facts to show that you were. That's the end of the matter. There's no appeal against that kind of finding. So I just want to end off because there's a reference in the referral to Katz and Tezel, which has been misrepresented. We we respectfully submit by the Commission, and it's at paragraph, it's at 428, page 428, and it's paragraph 184. It's 184, and it's page 428. And at 184, the following is said. On 18 October 2012, Katz, Ayer, Williams and Cummins were participants in an implicated chat room in which the following communication took place. Now we know that at that stage Katz is not employed by ANZ, so this can't affect ANZ's position in relation to Katz. Katz and Ayer matched each other's opposite fixed positions in order to offset their respective exposures at the upcoming fix. Now comes the crucial part for Tesel. Ayer copied and pasted a portion of a communication between Madras and Tesel from another chat room, not an implicated chat room, just another chat room. Now, we do not know what that communication was. We do not know the purpose of the cutting and pasting. We do know that it was not Tesel who copied and pasted it. It was Ayer who copied and pasted it, who was non-employed by ANZ. And it's been suggested to you, for some reason which escapes us completely, that you must assume that Ayer was actually in the same room, same chat room, as Tesel. But where does that come from? That's not alleged. It's not on any interpretation of this allegation. You can't find an allegation that they were actually in the same chat room. And in fact, it's counterintuitive. Because why would you need to cut and paste and send to another chat room a message from Madras to Tesel for your own purposes? So the degree to which this paragraph has been tortured into shape through inferences, assumptions, leniency in terms of pleadings is remarkable. The fact of the matter is it doesn't implicate Tesel, it doesn't implicate Katz. This is the only allegation against Tesel, and as far as Katz is concerned, it's too early. So, at the most fundamental level, there is nothing at all against ANZ. And it's remarkable that we have been dragged through years and years of proceedings where the Commission has been given opportunity after opportunity to come up with something better. They've come up with nothing better. And it should now stop. They should let ANZ go. The purpose of CAC2 was in fact to refine the case for the Commission so that they would continue to be able to pursue the banks most centrally involved in the conspiracy, to make it into a manageable case, not to grab every conceivable bank to which there was a passing reference. And in ANZ's case, that passing reference is this one paragraph. You can leave out of contention the broad allegations that say, well, you, ANZ, participated in a conspiracy, because we can't answer that allegation unless you tell us who, when, and what. And that was never done. So our submissions are that the appeal in respect of, or rather the application for leave to appeal, at least in respect of ANZ, should be dismissed. There is no prospect of success. It raises no constitutional principle. It raises, at very best for the Commission, a question of fact. Thank you, Deputy Chief Justice and members. Those are our submissions.
Thank you very much, Mr. Loxton. You still have 3 minutes, but you
I'll
forgo
give them up to
those.
ski.
We're going to have to take a 30-minute adjournment, and then we'll come back. Thank you.